That cap of 15 years is critical. The judge cannot exceed it, but can go anywhere below it. So now the battle shifts. Leniency versus maximum punishment. Every word from this point forward is aimed at influencing where on that scale the sentence.
Mr. Burbank, are you ready on the sentencing on Johnny Jacobo Ramon?
Yeah.
Good morning, ma'am. Would you, Ms. Birch, would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Thank you. All right. Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death.
Notice the defense strategy immediately. Frame this as an accident, not recklessness. That single word can heavily influence sentencing psychology. The defense wants the court focused on panic and poor judgment, not intentional disregard for human life.
And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has. Yes.
Are there any additions or corrections?
No, you're not.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident.
This is a delicate pivot, acknowledging a death while still asking for mercy. But here's the tension. How do you minimize punishment when a life was lost? That's the balancing act defense attorneys face in cases like this, and judges hear that conflict loud and clear.
If you read the factual basis, which I know you did, person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as reference to his version. That is on page 1. And then was stopped up in Lumberton. He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case, but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Ottawa County that were taken care of. At the same time, what you receive basically time served, 90 days jail. The intoxication charge that I believe is from Hardin County was when he was arrested, and that's been dismissed or rejected by the, and probably because we're down here, so I just hope we did it. Your Honor, I asked for not. There's a death involved. And
This moment is huge. If the judge believes he truly didn't know he hit someone, that softens the perception of intent. But if the court thinks he knew and fled anyway, the sentence calculus changes dramatically. Credibility right here could decide years of freedom.
I would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than 15 because I know where he's going to go, and that's a sad thing, but he's not here legally. And I don't know if he would like to address the court.
Sí,
Yes, here. Go ahead.
quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
pero pues había un carro con
Hold on. Hold on. So are you telling me that you didn't know you hit someone?
And now comes the prosecution's counterattack. They're not just arguing that he fled, they're arguing consciousness of guilt. The alleged deer story, the phone calls, the intoxication, even jail behavior. Prosecutors are stacking everything possible to paint a picture of someone avoiding responsibility at every stage.
Me están diciendo que usted no sabe que le pegó a alguien.
No, sí.
I didn't know.
Okay.
Y pero pues había un carro enfrente y yo no lo pude ver
There was
antes.
a vehicle in front and I wasn't able to see him in time.
Okay.
Pero pues quiero decir que lo siento, que
I want to say that I'm sorry.
si pudiera volver el tiempo lo haría, pero
But if I could go back in time, I would go back in
soy
time.
el culpable.
And I know I'm guilty.
Okay. Thank you.
I just have one question of him. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Estaba en el grupo
I was a ripper.
And how long have you been in the country?
¿Cuánto tiempo has estado aquí en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Simplemente un empleo?
Sí,
Yes.
And you do have a family?
¿Y si tiene una familia?
sí.
Yes.
Thank you. Mr. Smith?
Judge, we would argue for the max sentence in this case on the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls. The next day, he knew he hit a person. When he was stopped in Kuntz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon, obviously the facts of the case are terrible. The fact that you didn't stop. The fact that you were intoxicated. And in addition, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up. You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time find you guilty of accident involving death. Sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that. If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you.
This is where the hearing turns. The judge brings up the missed court appearance and ties it directly into trust and accountability. Sentencing isn't only about the original crime anymore. It's about whether the defendant convinced the court he deserved another chance. And from the tone here, you can already feel where this is heading.